Well, welcome. My name is James Dickey. I'm the Senior Trial Counsel at the Upper Midwest Law Center, and I'm joined by Jeff Van Nest, who is a Crime and Justice Policy Fellow at the Center of the American Experiment and Special Counsel to the Upper Midwest Law Center. Welcome to our team, Jeff, and great to see your stuff you're doing at CAE.
Yeah, great. Thank you, James.
So today we're going to talk about the decision by the Minnesota Court of Appeals that came out today in Spann versus the Minneapolis City Council. This was the case that in the end of last year, there was a decision by the district court that required the city of Minneapolis and specifically the city council and the mayor to fund and employ at least 731 active sworn officers on the police force. Today, the Court of Appeals decision reverses that, and it really truly was an illogical decision, as the concurrence in the case actually stated verbatim. And so we're going to break down that decision today and exactly what that means for the people of Minneapolis and the state of Minnesota. And I'll begin by talking about this decision in general. Here, the Court of Appeals made a number of really, to me, egregious errors in its reversal of the district court decision. It's really divorced from reality. The decision destroys the meaning of the Minneapolis City Charter and actually allows, there's a circumstance now that a rogue mayor could actually defund the police all by himself, despite the fact that the city just voted this last November overwhelmingly to oppose the defund the police amendment in the November 2021 election. The Court of Appeals decision itself actually even states verbatim that the position of the residents of the north side of Minneapolis, who we represent in this case, is logical, and actually notes that the city's position and really, frankly, the opinion itself is illogical, and that's actually stated directly in the case's concurrence. And so I want to talk about some of the court's biggest legal errors, and then we're going to go through what that means for the people of Minneapolis. So first thing the court does is the court ignores the distinction between what funding is in the city charter compared to what the city council has apparently represented and believes is actually funding. According to the court, as long as the city council writes down a number of officers on paper, that's good enough, even if the money isn't actually there to fund the actual number of officers. And so the court agreed here that the dictionary definition of fund, as we all understand it, to provide funds for, is what the charter requires the city council to do. But the court failed to actually recognize that requires there to actually be officers funded by that money in order to prove that the funding really is there, which is just the common sense understanding. If you have a number on paper that says 750 officers, but then you have 250 on the force, have you really provided the funds for it? And the answer that we thought is no. So what the court has actually done is they've blessed this practice of creating a ghost force in Minneapolis, which is a number on paper that doesn't translate to safety for the people of Minneapolis. And that is just a massive problem. And the second thing that the court goes out of its way to do is to invent arguments that really were never made in the case. We made it abundantly clear in our briefs and our arguments that the mayor, in this case, Mayor Fry, has discretion to do what he needs to do to get to the required number of police officers on the force. And we stated that from the very beginning. We were never trying to control the mayor's discretion. All we were trying to do, all our clients wanted, was that he arrives at that number. The way he comes to that number, that's not up to us. That's not what our case was designed to do, and that's not what the courts allow. And so the court decided that there were too many ifs and what ifs and that kind of thing to get that made it so that we were actually trying to control the mayor's discretion. But again, we never tried to do that. And we also have substantial evidence now from public reports and publicly available documents that show that other cities in the metro are actually crushing Minneapolis in terms of police spending and actually getting people to join the force. And so the city has claimed to the Court of Appeals, and the Court of Appeals basically relied on the city's statement that they were actually doing everything they could. But Jeff, my understanding from the research that you've done into public records is that that's really not true.
Yeah. So some of the media statements that have been made by the city indicates that right now there are approximately 284 patrol officers on the street right now. And from one of the law enforcement executives, the comment was made that number is insufficient to provide safety for residents of Minneapolis.
And that's down about half of what it was patrol officer wise a couple of years ago.
It is.
That's unbelievable. And I believe that there's also some information available publicly that states that other cities around the metro are actually providing bonuses and increasing salaries to attract candidates that Minneapolis isn't doing.
Well, that's right. So if you look online, I think it's the Minnesota Post Board has a roll up of all of the law enforcement positions throughout the state, and many of those postings do contain bonuses because those departments very much want to bring the talent to their agencies. So looking at just here in the metro, Roseville Police Department is offering a $10,000 bonus. Brooklyn Park is offering a $5,000 bonus, and then just looking around the country, other major cities are doing this, and Denver is offering a $15,000 bonus for a new officer to join the force. As of now, Minneapolis is not moving in that direction.
Right, and there's a recent headline in the Star Tribune that said that they were thinking about essentially floating the idea of a $7,000 bonus, but it hadn't been solidified yet.
That's right, and I would also say just the entering salaries as well. So the Minneapolis posting online is indicating about a $20 or so per hour salary for a new police cadet. So if you think about that, $20 an hour, if Minneapolis in fact did want to really bolster their force, is that a price point where they're going to get the type of officer that they want in the future?
Right. That's a good point. I mean, why work for $20 an hour for the city of Minneapolis and the police force with a city council that undermines you at every step, including by trying to actually defund and demonize the police, when you can get that same pay at other places for work that doesn't require advanced degrees of any kind?
Well, that's right. And I think it's worth making the point that it doesn't seem to be a monetary issue, because there are press reports that we've seen that indicate the city is prepared to allocate $7.5 million to the Violence Interrupter Project, which is something that, as we know, is untested at this point.
Right, and so the crazy thing about this decision, why the concurrence said, in fact, that this is an illogical position, at least how the city charter reads, according to the Court of Appeals, is that if there was a rogue mayor, and I'm not saying that that's Mayor Fry, but if there were another mayor instead of Mayor Fry who was committed to defunding the police, who took office, then this court's decision really paves the way for, even if the city council puts down a number, the mayor can just say, I'm not spending the money on the police. I'm going to take that money and put it somewhere else, even though it's been specifically allocated in the budget for the police force.
And James, and you're very familiar with the adoption of this provision and the purpose behind it. So what did the people of Minneapolis want when they adopted and they voted for this provision?
Right. They voted for this provision in 1961, and it was an overwhelming victory for this. I believe it was above 60% in the city of Minneapolis that wanted this, because crime was increasing substantially even back then in 1960, and there simply weren't enough police officers to do the job on the force. As soon as the amendment was passed and became law in the city charter, the city went out and started hiring cops immediately. They hired 190 new patrolmen. They did it in less than 6 months, and the way they did that was they increased salaries so that they would be more competitive. And cops were trying to leave Duluth at that time to make sure that they could get the best deal possible by working in Minneapolis. And the interesting thing is, we provided in our briefing throughout this case, we provided that evidence to the court. And what the court here did was they said, we don't have to look at the purpose of the charter in 1960. All we have to do is look at the literal language of this, even though it leads us to an illogical result, and that the Upper Midwest Law Center's position and our client's position is the logical one. We can adopt an absurd result that contradicts the purpose of the charter because we interpret its language to mean something. And it goes against statutory interpretation 101. It's just a wrong-headed decision. And what the crazy thing to me is that the court held that the 2013 amendment to the Minneapolis City Charter, called the Plain Language Amendment, which on their website, at least before I release this to the public, at least said, and I can almost quote it, that this was just designed to update the old language of the charter. The meaning of the charter was going to be the same from 2012 to 2014 and onward. It was just going to get rid of the wherefores and the theretos and the heretofores and all that older language that no one uses anymore, but keep the same meaning. And the language in 2012 of this particular provision of the city charter said this: the personnel of the police department shall be established and maintained at a ratio or as closely thereto as is possible, there's one of those theretos, within the limits of section 2 hereof, not less than 1 7/10 employees per 1,000 of population of the city, according to the latest United States official census. So under our understanding, that provision should have the exact same meaning in 2012 as it does in the charter today. But the Court of Appeals said that the meaning today was that there doesn't have to be the ratio maintained at near that number, as close thereto as possible. The Court of Appeals said there's no obligation for the mayor to maintain the police force as close to that ratio as possible. And it demonstrates a situation where the judges are trying to do what they think is the right thing with statutory interpretation, and they get so lost in the trees that they don't see the forest here.
Well, it's interesting, you mentioned that because, this issue of funding the police was before the voters most recently, and you made the comment about a ghost force. Do you have any impressions about the will of the voters from last fall in respect to properly funding the Minneapolis Police Department?
Well, I think that the voters were really clear, as we talked about earlier, that it was a substantial defeat for the Defund the Police amendment to the Minneapolis City Charter. And if you were to tell the voters on Election Day in November 2021 that just a few months from now, the Minnesota Court of Appeals would actually allow a mayor to do exactly what they voted could not happen under their charter, I think there would be significant shock and awe. And I will also note that our clients, who are 8 white and black residents of Minneapolis's north side in the Jordan and Hawthorne neighborhoods, they are still dealing with bullets ripping through their neighborhoods as they duck from gunfire. And I know they didn't support that amendment, and there's a reason why. In this case, in this decision by the Minnesota Court of Appeals really just does away with their hope for safety in the city of Minneapolis. And it's a downhill road from here unless the Minnesota Supreme Court steps in and does something.
And so that's my next question. What is the next step for this case?
Well, we're going to appeal this case rapidly, and we're going to seek expedited review from the Minnesota Supreme Court. There is no question in our minds that this decision was wrong today. We are not going to let it stand. We're going to do everything we can to get an expedited decision from the Minnesota Supreme Court, hopefully before the end of June, which is when the district court had said in the writ of mandamus that the city had to show that they were in compliance with the charter minimum. So that's our goal, and we have really good precedent on our side in this case, and it's actually precedent that the Court of Appeals entirely ignored, did not even mention in the decision. There was a case back from 1935 where the Minnesota Supreme Court noted in a footnote, and I know it's a footnote, but the Supreme Court said it, that if there were a minimum funding provision that they were looking at, as opposed to in that case a maximum funding provision, that they might find that there would be a requirement that the official in charge of implementing that policy use those funds for that policy. And I just think that that's common sense to everyone in Minnesota.
Completely logical.
Right. And, as we said before, the Court of Appeals even said, even though they disagreed with us and held against us today in a really bad decision, they agreed that our position was the logical one. And so we hope the Minnesota Supreme Court will see that too.
Fantastic. It sounds like we should stay tuned.
Absolutely. A lot more to come.